Welcome to our July meeting of the Developmental Disabilities Committee, and I'm Sherry Nakamoto.
Now we can't hear you. This is Maimuna. We cannot hear.
Oh, I can. Maybe it's yours.
Okay.
Can someone raise a thumb if they can hear?
Yes.
Oh, why can Lucy hear but nobody else then?
Oh, I can hear now.
Okay, Lucy can hear. Maimuna can hear. So the voice is.
I'm just turning the volume up a little bit.
Okay. Lucy has special powers. That's how. So I'm the co-chair of the Developmental Disabilities Committee. I co-chair this with Bertram again. She's either on remotely or she will try to join us remotely. So thank you everyone for coming. Just before I get started, I also want to let folks know that Joe Albert was not a voting member of the Developmental Disabilities Committee, but he has been on the DD committee and he has agreed to be a voting member. So we have a quorum and we can begin our work. At this point, let me have folks introduce themselves. We'll start with the folks online, and what I will do is I will go to Teams and I will look at the participant list and call you out as I see you. First is Barbara Jones, who is a voting member of this committee participating remotely. Barbara, you want to introduce yourself? Turn on your mic, please.
You're muted.
Turn on your mic, Barbara.
Unmute yourself.
Sorry about that. Barbara Jones, I'm a parent and a member of the committee.
Andrea Blackman.
Andrea Blackman, excuse me, and I work with Arlington Weaves.
Service source for purposes of the minutes.
Service source, yes.
And former co-chair Carol Skelly, winner of many awards. Carol?
Thanks, Sherry. I'm Carol Skelly. I'm a parent and former member and chair of the committee.
Thank you, Carol. Debbie Alexander.
Hi, Debbie Alexander, Executive Director of Specially Adapted Resource Clubs.
Denise McDonald.
Hello, my name is Denise. I am the management intern in the guardianship program.
Joy Haley.
Hi, my name is Joy Haley. I'm a transition coordinator with Arlington Public Schools.
We're so impressed that you're here. Out. Thank you for coming. Ivy Brooks.
Good afternoon. I am Ivory Brooks, the program director for Melwood Arlington's day program, sitting in for Taquanda Dixon, who is the CSD director for Melwood.
Thank you, Ivy. Janine Rennie, or Jeannie Rennie.
Hi, I'm Jeannie Rennie. I am the aging parent of an adult daughter with a developmental disability.
Great, we want to hear from you today. I'm going to skip Joe. Kay.
Hello, Kay Tiernan, and I'm a parent, non-voting parent on the committee.
Great. Lucia Plaster.
Hi, I'm Lucia, and I'm a parent on the committee.
Thank you, Lucia. Lucy.
Hi, I'm Lucy Beednell from the Arc of Northern Virginia.
Great, thank you. Maimuna.
Hi, I'm Maimuna Ba-Duckenfield, Division Director for Aging and Disability Services.
Moira.
Hi, I'm a parent with Tommaso Sato of a 33-year-old autistic man named Michael who lives in an Arlington group home.
And then Kay.
You already got me. I'm on just on the bridge.
I should probably jump around.
Oh, stop jumping around. Okay, and now I'd like to introduce the folks in the room. We'll start with Tom.
Good afternoon. I'm Tom Bailey. I'm Administrative Outreach Specialist for Aging and Disability Services, and I am the recorder for this particular meeting.
Lynn?
I'm Lynn Cosma, a parent and a member of the committee, and I also have a 33-year-old son who has cerebral palsy and was in school with Michael Salcedo many years ago.
Good afternoon, LaVoice Reed, and I'm here on staff with DHS Bureau Director for our Clinical and Developmental Services Bureau, and I also serve as the staff liaison to the DD committee.
You heard from me, Sherry Takamoto, but I have to say that I'm the parent of a 35-year-old who went to school with Lynn's son Steve and Laura's son Michael. And I'm an aging person with a disability.
I'm Donna Budway, member of the parent, member of the committee, and I have a 26-year-old daughter who has a disability.
Yeah, okay, sorry. My name is Joseph Albert. I'm a member of the CSB committee, and I'm also a member of the committee.
Thank you. Laura Edelbrook entered while we were introducing ourselves. Laura, do you want to introduce yourself?
Yes, I'm Laura Edelbrock. My daughter Emma is 23, just finished up with the PEP program, and we're trying to figure it out, but we are an older generation parent. We probably could have had a generation between us and our kiddos, so very interested in today's topic.
Great, well, welcome, and we're so happy you're here and we're able to join us. So at this point, I'd like to ask if anyone has public comment they would like to share. Okay, then we'll move to approval of the May 9th, 2023 minutes. And these went out in advance of the meeting. I have a couple of corrections, Tom. One is that we had a virtual attendee, and her name is Huong Pham, not so that we misspelled her name. The second is that under public comments, Paul Osgood expressed support for the state rental assistance program that helps him live independently in his apartment. Donna, since he's there, is that pretty much?
I'd like, thank you, because I was there and I should, I think it's better to expand that, to express that. I agree.
That he expressed support for the SREC program.
Yes.
Okay.
Right.
And then the final is that at the end of the meeting, the committee approved a motion to ask the CSB for support of, for acceptance of 10 state rental assistance program vouchers available from, I don't know what all the letters stand for, but it's BBHDS. Are there any other corrections or additions to the minutes? So is there a motion to accept the minutes?
So moved.
A second.
Yay, okay. And then since there were no other additions or corrections, the minutes have passed. Thank you, Tom, for all your work in doing these for us. We appreciate that. Next, we have Lucy Beadnell from the ARC is going to present the ARC update. Do we have a budget, Lucy? It's July, you promised.
In terms of budget, we have no budget. Very, very frustrating situation in which to find ourselves. So now even the things that were all but assured that we would get, meaning that they were in the governor's budget and not touched, or in both the House and the Senate reconciled budget that we were just waiting for the formality of the budget to be signed to happen, we can't touch. So that would be things like combining caps on assistive technology and environmental modifications, or a 5% raise for direct caregivers, or those kinds of things that seems in the slam dunk territory. So that's very frustrating. To state the obvious, we are as eagerly awaiting that budget as anybody else is. I was talking with some House aides yesterday. They did not share any insider tips or hints that I can pass along. So I don't even have good whispers to share. As we had talked about before, this is sort of a mishmash of issues, which is the overwhelming majority of the money people on the Senate are retiring or have lost their primaries. And so they're on very odd footing. Some federal budget stuff has shifted, and there's some political posturing, I'll say, that's going on at the state level that's all sort of happening in layers that are making it harder than usual to get a budget out. So as soon as it does, we're happy to share news. In that vein, I was going to say that in September and October, we're going to be having a series of 8 candidate forums where you can hear from people running for House and Senate. I think it's just going to be one night that covers all of Arlington and Alexandria, but we'll have a couple of nights for Fairfax, Prince William, Loudoun. It's going pretty far reaching. And as soon as I have those dates in a shareable format, I'll pass it on. But attending meetings like that and talking about the same kinds of things we do here, it's stressful to age and not know if there's a waiver. It is very hard to navigate services if there's no budget when we tell our care attendant they can get a raise. Like all those kinds of things, we want to hear from you all. Attendees at those forums, people who send in questions in advance or live ask questions really help move the envelope forward. And as a reminder, all of the House and all of the Senate are up for election this year. So anyone who represents you in Arlington in House or Senate is going to be on the ballot, and it is a chance for them to hear from you as much as it is for us to hear from them. I was going to also add that some changes have been evolving. During the pandemic, parents had the first time ever flexibility to be paid caregivers to minor children less than 18, if that child had a waiver. That was a flexibility during the pandemic for obvious reasons, right? It was harder to bring other folks into the home. There was a lot of push to make that permanent, and the way it was made permanent was going to require parents to work for an agency to oversee caring for their own children. That has now been shot back down, and there's now a plan to allow parents to do what they had been doing, right? Work through consumer-directed services, meaning directly through the waiver. Parents are going to be capped at 40 hours per week, though, of the amount of care that they can provide for minor children. Again, these are limits to parents caring for kids under 18. But until November of this year, we remain under Appendix K's flexibilities, which are exactly as they have been for years. Starting in November, we'll move to these new regulations that say, yes, as a parent, you can do it. Yes, you can do consumer directed or agency, but you're limited to 40 hours per week, and you've got to log in on an electronic timesheet. I wanted to put a little plug in here to say we are hearing more and more from people who are struggling to get companion care authorized, capital C for companion, capital C for care, the proper name for a service. It's a one-to-one service that can be used by people living in congregate settings like group homes, if there was a time when a one-to-one companion was coming in to work just with that person, or in your home or your own apartment, right? It can be used in lots of settings, but if you or someone you know has struggled to get companion care, especially I'll say if in the last year-ish, it has suddenly started to be denied, I would love to be connected with you. There's a family that's trying to lead a charge to look into this. And since someone is willing to take the mantle, I think it's a great opportunity to do some advocacy. The other things that I wanted to share are just that our state convention is coming. It is a tremendous opportunity to hear from Medicaid, the Department of Justice, other families and advocates all over the state directly. I'll put a link in the chat. It's at the end of this month, July 31st to August 2nd. And for the first time in a decade, at least, it's in Richmond. So not a terrible commute, even if you just wanted to go for a day. or so, and they have the sessions and things posted. They'll be doing the keynotes virtually, but not the breakout sessions. And I am partial to the breakout sessions because that's when you can usually get into nitty gritty things, whereas the keynotes I find are more exciting and inspirational, but not where the policy wonks live. And then the last thing is that we have a number of brand new workshops coming up. There's one called Caring for the Caregiver, which we've never had before, with a national speaker coming up. Our transition series is back this fall, that all-day, 2-day Saturday session to help families who are leaving the school system and moving to the adult world. Our tech team is doing virtual tech camps, so people with disabilities can get free customized apps to help them to learn to be more independent at home or travel training or in a host of situations, work and daily living skills. And always we have special needs trust webinars and things like that. So that's all the kind of stuff that's going on and what's not. I'm happy to answer questions if anybody has them.
I have one, well, I have a couple of questions. One is for companion caregivers. That's a service authorized under which of the waivers?
It's available under the DD waivers, the community living and the FIS waiver, as well as the CCC plus waiver can have companion care.
Excellent.
Just not doing independence. Yeah.
Number two, the ARC conference, they will accept something called individual and family caregiver training support to pay for registration. So that's something that you need to ask if you want to go and you would like to be able to afford to go. Lucy, as I understand it, it's a great place for people with disabilities to go and meet up with other people with disabilities and have a cool time. So if you are a person with a developmental disability or you're a caregiver for one, that's a nice opportunity to go, and you can call your service coordinator to ask to get that authorized. You need to do it soon.
And that's under the family and individual supports waiver.
Yes.
Not the CL waiver. So
and I'll put in a plug that I know it's not realistic for everybody between now and 20 days from now when that convention starts, or 10 days from now when registration ends, to maybe talk to their support coordinator this year and get it done. But now that the ARC is set up to accept that family and individual support waiver, the FIS waiver line item, when you're doing your annual plan this year, maybe ask for that money next year in advance, right? Get it in your plan if you don't have time this year, knowing that you can use it in the future.
And one last thing, because I always read my ARC newsletters, is that we have the Olmsted hearing on the 27th of July. Tell us why we might be interested in that.
Yeah, so we are now 12 years approximately into a 10-year legal settlement, which is a clue there that, right, that we haven't met the terms of the settlement. But the judge who is looking at letting Virginia out of this settlement, which would mean no more mandates to, and not the same level of oversight over things like crisis services, case management, kids in nursing homes. It covers a wide scope of disability services. And so if Department of Justice pulls back, that pushes some of the force that has been moving things along away. Not that it's been a perfect settlement agreement, but it certainly has been an impetus to making things happen. So that settlement agreement is mostly the judge planning to hear what he thinks is going to be wrap-up arguments. Are we about ready to bow out of this agreement perhaps at the end of this calendar year? I would say the ARC of Virginia is pushing really hard to have a big showing there from people saying, I don't really think we're where we need to be as a state in terms of the availability of waivers and crisis services and other kinds of quality community-based care. We would like to stay under this settlement agreement that forces some other kinds of options along. And so it's open to the public. There's not an opportunity for the public to speak there per se, other than your presence speaks volumes. People who go down and spend a day sitting in that courtroom, I'm sure the ARC of Virginia is going to have people wear orange or sit together, those kinds of things, is a way to make an impact, or at least to hear about what's going on if you're interested. And Sherry, I'm happy to send a little blurb about that along with the notes that I shared tonight if you want to get it passed around.
Okay, thank you so much, Lucy, for all this. Okay.
Can I say one more thing?
Sure, Joe.
Sorry, I had two questions actually.
Thank
You go ahead.
One, is there, with the companion service, the group that's trying to advocate, have they specified, because there seems to be, an increase I've noticed in general with other services also being, people having tougher times getting their services. maybe especially this year. Has there been an explanation on why there seems to be a tough time getting the service or an understanding of what's happening there with the companion service and why it's so tough? Or at least a theory of a working theory of what's happening there?
I would say the diplomatic answer to that is that no rules have changed related to companion care or how it would be authorized, but we have seen a trend where it is being denied. And so we have raised this concern with the Department of Behavioral Health and Developmental Services. And I think we're now at the point where they're saying, okay, give us some examples and we'll work through those, which is why I would love to hear from anybody who's having this sort of situation happen to them, because that will show that this isn't just one or two people where this is happening. It's a system-wide thing, and then help us push to have it fixed system-wide.
And then with the hearing that's happening, you know, no one has a magic 8 ball on this, but and to make these guesses and that, but I mean the argument against, I guess, this settlement and that, and how likely a judge would rule against this or that, how likely would it be that this would be overturned or something like that? Is there political signs that there could be kind of a because that would be a pretty big hit, would it not, if if this was overturned? I mean, the settlement. So I mean, how likely could that happen, and what would occur if that was overturned? I mean, what steps would be taken to salvage anything? I'm just curious.
It's a good question. So to just continue the settlement, to just say, Virginia, I am not letting you out at the end of this calendar year, would not be a big overturning or create a lot of political upheaval. And I think that's the hope, that just the terms of the settlement will be extended longer, to have Virginia, using my terms, under the microscope a little bit longer. My guess would be at most a year is the maximum that could possibly happen. And it may be something shorter if it happens at all. But this is sort of the last hope at having that higher level of oversight in place a little bit longer.
Can I also comment on that question? So we are currently on schedule at the state level to exit the DOJ settlement agreement December 31st of 2023. That is an extension of a year and a half past the June 30th of 2022 date for which the judge granted the extension of that. And there are certain indicators and measures that we have at, and DBHDS, the Deputy Commissioner Heather Norton, is very optimistic that we will get there. And so there's still some indicators that are not fully in compliance. So, but we're on track for that. And so in the event that it gets extended, I would agree with Lucy, maybe 6 months to a year. I don't know that a full year would be necessary in terms of that. The judge is also looking at getting into compliance and sustaining compliance as well. And so they're tracking the indicators that we have met up to date. So there are some indicators that we met 2 years ago, some we met 6 months ago, some that were met a year ago. So several of those indicators we've been in compliance with for at least a year. The department is also greatly committed to sustaining all changes that were made as a result of the settlement agreement. So once we exit the settlement,
I'm on a Zoom
it's
call.
important to know that all of the indicators that have been put in place will continue to be enforced by the department. The likelihood, Joe, of this whole thing being overturned, yeah, that would be detrimental, but that is a 0 probability of happening.
Okay, thank you, I appreciate it.
Donna, you had a question?
Just a comment that the big keynote day for the convention, and I don't know if anyone else in the committee is trying to go, but is the day of our next CSB meeting. So just, like, I kind of committed I'd be there.
That's okay, because we don't have an August.
We're not going to have an August meeting. That one got taken off. Okay.
Thank you, Donna, for reminding us, because I'm very good at getting my dates wrong. But, so thank you. Okay, any other questions for Lucy? Thank you, Lucy, for always bringing us the latest and greatest. We appreciate it. We're lucky to have you.
happy to be here. Greatest may be a stretch. Good job, Mommy.
Speaking of lucky to have, we now have Denise McDonald, who's going to share with us some information about aging people who have guardianships over aging people with disabilities, and also share some information with us about her role in being the guru of guardians in Arlington County. So thank you, Denise.
Oh, thank you. I'm very happy to be here. Maimuna, I'm putting in a petition for Guru of Guardianship to be the official title. I love that. So first off, some of you guys' names sound very familiar to me, so it's exciting to be able to put like voices and names to them. I read all of the guardianship reports, so I have seen many of your guys' names across my desk a few times, so this is nice. Bear with me for half a second while I figure out the sharing screen. Let's see. The dual screen makes it a little funny. Did that work?
Yes.
Okay. Wonderful. Okay. Just trying to figure out where all the slides are. There we go. Okay. So I do want to start with saying some of the data points on our aging guardians, that's a little bit harder to find. So I don't have really good data about that just because we don't keep track of the birth dates or the ages of our guardians. So I'm kind of working on a workaround for that. But I'm here to tell you about guardianship as a whole, some other alternatives, and then some things about future planning. So to start off, my most recent figure, there are 449 active guardianship cases in Arlington. Of those, there's 136, which is about 30%, that are receiving support coordination services through the DD program. So a pretty big chunk. That's why so many of you guys sound so familiar to me. So when we're looking at autonomy, decision-making, guardianship, this is a joint position statement from the American Association on Intellectual and Developmental Disabilities and also the ARC. So their current trends presume that the decision-making capacities of individuals with IDD and the preservation of legal capacity as a priority for all people needing assistance with decision-making. So we want to have people have as much autonomy, as much of a say in the decisions that are being made as possible. Like peers without disabilities, individuals with IDD must be presumed competent. So one is presumed to have competency, be able to make decisions unless proven otherwise. The individuals with IDD are also, they should be assisted to develop as decision makers through education, supports, and life experience. An important note is that communication challenges should not be misinterpreted as lack of competency to make decisions. So every effort to try alternative methods of communication should be tried, and just not assuming that there's a lack of understanding. And then this is true both for individuals with IDD or anyone that like a guardianship might be an option for. The less restrictive means of decision-making should always be tried first and found to be ineffective. We'll talk a little bit about what some of these alternatives are, but you want to try some of these first before using guardianship as an option. So a little bit more about decision-making, because that's really what this is all about. All adults have a right to make choices about their lives. If an adult needs help with making those decisions, whether that's health or personal, or if that's managing money and property, they should be supported. These supporters can be trusted family, friends, professionals, some of our estate and elder law attorneys, other people or organizations that help the adult to understand their choices, make choices, and then communicate the decisions appropriately. Supports can be informal, so that's just family members helping out with making decisions. They can be formalized through legal documents like power of attorneys, which we'll talk about a little bit more as well. These supports can be for health and personal decisions. So for the person, that includes where they're living, if we're consenting to medical procedures, or also financial decisions. If an adult needs help managing his or her own life decisions and there are no supports, a court may appoint a guardian or a conservator to make decisions on that person's behalf. But again, this should be a last resort. Guardianship and conservatorship take away basic human decision-making rights. So like the right to enter into contracts, to marry, to vote, things like that, unless they are otherwise specified, are taken away when guardianship goes into place. So that's why it's always our last resort. So when we talk about alternatives, these least restrictive means, these are things that you want to try or have evidence that they will not work before moving forward with guardianship. Some of these are maybe not as relevant to our DD population. It's very situation dependent. But on the medical side, you have your advanced directives, your mental health advanced directives, medical powers of attorneys, and then the physician orders for scope of treatment, also called posts. You have financials, so authorized signers, where if one person is signing a check or making a payment, somebody else has to sign off on it as well. Joint accounts, Social Security representative payees, and then the Veteran Administration fiduciaries. And then there are durable powers of attorney. And then there's a third kind of category that's called supported decision-making agreements. These are very different. These are for individuals who have capacity. So they haven't been found incapacitated by courts. There's no questions on the medical front about capacity to make decisions. They retain decision-making authority for themselves, but they have supports in place that they consult with for guidance. And I'll go in a little bit more on the next slide. I think this kind of helps you visualize. This is the continuum of decision-making supports. So we go from the least restrictive to the most. So again, the least restrictive that you can possibly have is going to be these supported decision-making agreements. These are formal documents. Sometimes you see an attorney kind of get involved and help write those up. But this is written for an adult who's capable of making those decisions with support of others. These documents state under what conditions, what circumstances they want support, who they want to support them, and how they want that support to be received. So you're really putting the power in that individual's hands. Moving forward a little bit, you have advanced directives. These require still that the person has the capacity to make decisions. These are written agreements, written statements that address the forms of healthcare that you would consent to if you are later later incapable of making a decision. You then have your powers of attorney. So in Virginia, we have advanced directives and medical powers of attorneys are kind of the same thing. In this case, you would be granting someone to be an agent or give them the authority to make those medical decisions on your behalf. And then you have your durable powers of attorney, which are on the financial side. That allows somebody to access like your accounts, make payments on your behalf. If there's any court cases involving financials, they can appear on your behalf, authorizing payments, those kinds of things. Moving forward, you have authorized representatives. These are individuals that are designated to act as substitute decision makers for people who are receiving care from DBHDS licensed providers. So it's your person lacks capacity. They don't already have somebody designated to make decisions. They don't have a guardian, anything like that. They would have an authorized representative. And then on the end of the most restrictive, you have temporary guardianship and limited guardianship, and then full guardianship. And then we'll go into that a little bit further as well. So least restrictive to most restrictive. That just kind of lays that out for you. Okay, so when we're talking about representative payees, I feel like this is one that might be a little bit more relevant for your families, your client base. These are for individuals that receive government benefits, so your Social Security, your disability, those kinds of things. That agency has processes for selecting a representative. That can be a family member, that can be an attorney, a group home, or something like Nova Rep Payee Services. And they help manage those benefits, make sure medical payments are being made, any payments to group homes, things like that, living allowances, making sure that everything is properly outlined. So this is only managing that government benefit. This isn't any other money or property. If they have a job and they get paid biweekly, you're not managing that money. If they own property, this doesn't give you the rights to that or anything like that. The representative manages the money for the benefit of the person, not for their own benefit. They have to manage it carefully, keep it separate from their own funds, and keep good records. The Social Security Administration can actually audit and request records, receipts, just to kind of see how the money is being spent, make sure it's being spent for the good of the person who's receiving the money. So that's the representative payees. Okay, and then we talk about guardianship. I know a lot of you have a very good understanding of guardianship. A guardian is someone who's appointed by the court responsible for the affairs of an incapacitated person. As a guardian, you're responsible for decisions about the person's support, their care, health, safety, rehabilitation, education, therapeutic treatment, and residence if indicated. So if they're going to school, if they're going to day programs, physical therapy, occupational therapy, all those things, you're responsible for setting that up, consenting to services, and so on. Under the full guardianship, you have limited guardianship. These are guardianships for an incapacitated person who is capable of addressing some of the essential requirements for their care. In most of these cases, they're the limited purpose of medical decision-making, so consenting to medical treatments, prescribed medications, deciding places of residency, whether they can be admitted into a hospital and things like that. It's important to note, under any type of guardianship, you can consent to treatment and medication, but you cannot force medication and treatments, so that's not something that guardianships allow for. And then there's also temporary guardians, exactly as it sounds. There's a defined time frame. These are typically in place until a permanent guardian can be appointed. The powers that are granted to a guardian are only what is outlined in the court order. Nothing more, nothing less. So if it's not written, then that's not a power that you have. So that's why you want to consult with the attorney that's helping you write this up, make sure everything you need is in there. So as a child, when a child turns 18, the legal capacity to make their own decisions becomes theirs. So all their decision-making rights are transferred from their parent or guardian, unless a court is appointing a court-appointed guardian. That's their right to manage finances, decide where they live, making healthcare decisions and appointments. HIPAA goes into effect there. You can no longer call the doctor and ask, how'd the last appointment go? What medications are we prescribing? Things like that. In Virginia, petitions for guardianship can be filed no earlier than 6 months prior to the respondent. In this case, this would be your child, your client's 18th birthday. So general recommendation, you kind of start around 17, gathering your documents. At 17 and 6 months, you can officially file the petition, so it's in place when they turn 18, so you don't have that gap in care and access to records. Guardianship terminates the rights of the child, so that's just the big thing there. That's why it's a last resort. But these rights can be restored as they grow and develop. So as they become more capable of making decisions, you can give them more rights back, give them more of an ability to exist outside of the guardianship. Okay, and then we talk a lot guardianship versus conservatorship. Some states, they use the words interchangeably. It's all a guardianship, it's all a conservatorship. In Virginia, they are separate. So guardianship, you think of the person. Conservatorship is more property and money. So a conservator is also appointed by the court, but they manage the estate, so any property, and financial affairs of the incapacitated person. And then you might be wondering, well, why do you need a representative payee if you have a conservator? Great. Representative payees, those are only those government benefits. If that's the only income you're really looking at managing, a representative payee will cover most of the bases. If you're looking at, there's trust money involved, there's a large inheritance sitting in a bank account somewhere, there's more money than just like Social Security. You would want to have a conservatorship in place to be able to manage those finances. And then because these are separate, conservatorships are managed in a separate office. They go to the Commissioner of Accounts. And then we talk a lot about being an incapacitated person, the incapacitated person's guardian. What does it mean to be incapacitated? This is, excuse my Alexa going off in the background, I'm sorry. An incapacitated person is an adult who has been found by a court to be incapable of receiving and evaluating information effectively, or they cannot respond to people, events, the environment to such an extent that they are unable to meet the essential requirements for their health care, their health, their care, their safety, or their therapeutic needs without assistance or protection, or they're unable to manage their property or financial affairs without the assistance of a conservator. So someone who is unable to really understand the gravity of a situation, understand what is being asked of them, what is being required of them. A finding that an individual displays poor judgment alone is not sufficient evidence to be incapacitated. We often say, you can make bad decisions all day long, but as long as you're effectively understanding what's leading up to this decision, understanding the consequences or potential consequences of said decision, then you are not incapacitated. And then only a court can find someone to be incapacitated. And then we look at the steps to be appointed as a guardian or conservator. You've got 6 big steps, more or less, sections. The first is the petition. So any person can file a petition in a Virginia Circuit Court stating that a resident of Virginia needs a guardian or conservator. Once that petition is filed, the judge appoints a guardian ad litem. The guardian ad litem investigates the statements in the petition, reports to the court. In that same hearing, the judge hears the evidence that you as the petitioner have provided that the respondent, this would be your child, your client, is incapacitated. These include your psychological evaluations, your physician statements, medical records, those kinds of things. This all takes place at the hearing. You as the petitioner schedule the hearing where the judge hears your evidence, hears the guardian ad litem's report, and then makes a determination whether the respondent is incapacitated. If they rule yes, then they issue a court order. That's the responsibility of the petitioner or their attorney to write up the court order of appointment, and the judge signs it. That officially appoints you as guardian. But very important step, you cannot act as a guardian until you have qualified before the clerk. So in Arlington, you just go downstairs to the clerk's office post-hearing. They have some forms that you fill out, you take your oath of guardianship, and then you get your official letter of qualification. After that, you can serve as guardian. You have all the powers you've had, prior as a parent. So that's the last step, but arguably the most important. And then breaking it down just a little bit more. So when you're filing your petition for guardianship, you have to file it in the circuit court of the city or county where the respondent is a resident or where they were a resident prior to being admitted to a hospital or like a nursing facility. Any resident of Virginia can file a petition for guardianship. The recommendation is not to try and do it by yourself, though. You can always call the clerk's office. They'll walk you through the process, but there's a lot of little steps and requirements. It's complex is what it's always told to me. So we always recommend that you have the elder law attorney or an estate law attorney that will assist, just to make sure everything's being filed right the first time. You're not going back and forth, paying extra filing fees and all of that. And then we talk about the guardian ad litem. A guardian ad litem is another attorney. They're appointed by a judge to help the court make a decision. The guardian ad litem does not represent a person. They're a neutral third party. They give the court independent views about what might be best for the respondent. So they're allowed to conduct interviews and investigations. They can talk to you as the parent, healthcare providers, the respondent, just to kind of substantiate the claims of incapacity. And then they make a report to the court and participate in the hearings. The main reason a guardian ad litem is appointed is to just ensure that the rights of the respondent are being respected, that the claim of incapacity is valid, and we're not taking rights away just for no reason, just because somebody said it was necessary. So it's just a safeguard for the client, for your child. Okay, And then we talked about evidence. We said that that includes the report that evaluates the medical condition of the respondent. That can be prepared by a licensed physician, psychologist, anyone who is a licensed professional and is skilled in the assessment and treatment of whatever condition the respondent has. Ideally, it's someone familiar with their case. You can have multiple physician statements, whatever you feel is necessary. The court also considers the following when they're looking at evidence. So the capabilities of the respondent. What are they able to do unassisted? What are they really able to understand? The development of the respondent's maximum self-reliance and independence. So even in implementing a guardianship, are we still making sure that the respondent is involved in decisions, in that their wishes are being taken into account as much as is feasible? There's also the availability of less restrictive alternatives. So they ask, have you tried any of those least restrictive alternatives, like a power of attorney, a supported decision-making agreement? If you did and it didn't work, why was that? What was unsuccessful? If you cannot try it for a very specific reason, which there definitely are, what is that reason? They also look at the extent to which it is necessary to protect the respondent from neglect, abuse, or exploitation, what actions need to be taken by the guardian or conservator, and then the suitability of the proposed guardian or conservator. So we take all of that into account, and then the judge makes a ruling. So now you've been appointed. Some of this for our parents or guardians, this might be a little new. We changed the code, not we, the legislature changed the code on July 1st of this year. So your big responsibility, you're expected to visit the incapacitated person as often as necessary. What's new this year is that means at least 3 times per year. A lot of you live with your children or live near your children, so that's not really a big deal, but that is a new change to the code. These visits are as often as necessary to know what their capabilities are, what limitations, has anything changed? Are there any needs, any areas that need to be addressed? Unless otherwise specified by the court, you're responsible for the personal affairs of the incapacitated person. So you're making the decisions about their support, what caregivers are present, what doctor's appointments they're going to, if they need urgent care or an emergency visit, are they living in a safe environment? What other treatments are you consenting to? And then also where they live. Depending on their condition, the least restrictive living arrangement is usually best. The incapacitated person's home is usually preferable to other living arrangements. Again, that's individualized per person. Are they better suited at home? Is a group living environment more suitable? Or are they one who can live independently with community supports? Again, all dependent on the person's condition. And then the last 2 big requirements, you have to notify the court and Department of Human Services if you move or if the incapacitated person moves. And then you also have to notify the court and Department of Human Services and submit a final report if the incapacitated person passes away. So those are the big requirements. That's what's required by the code. In addition to filing the initial and annual report, which you all are all very familiar with. And then the big thing here is when you're looking at future planning for yourself as parents and guardians. The first thing you can always do, you can designate a co-guardian. I think that happens pretty frequently in some of our DD cases. You can designate another adult to serve alongside you as guardian, whether that's 2 parents, 2 guardians, you're appointing a sister, a brother. Those co-guardians can act together or separately, depending on the court order. That has both guardians active at the same time. So if something were to happen to the other, there's somebody already qualified and in place to take on the guardian role. You can also, in this court order, when you're originally appointed as a guardian, designate a standby guardian. So when you're petitioning for guardianship of your adult child, you're designating someone that's going to take over in the event you yourself become incapacitated or pass away. This person does not qualify until they are needed. So they are just kind of listed in the order, and then when the time comes, they go and qualify and they're ready to serve. You can also nominate a guardian in a will. So it's kind of the same thing. You would nominate them in your will, and then they will still have to go and qualify. It's kind of the same way as designating somebody in the order. The recommendation is that you do both of these things because that limits any questioning of like your choice in the matter. Like nobody can argue that you didn't mean it because you've now written it in 2 places. It's kind of the understanding. So you should do both. Ultimately, you can also, if it comes down to it, and something is to happen to you as the parent, we have our volunteer guardianship program. There's public guardianship slots as well that we can look into. So there are other alternatives, but these are your best cases for ensuring that somebody is there and somebody that you know and trust. So those are our big ones there. I also included, I thought this might be helpful. We have a guardianship training that we provide to mostly our new volunteer recruits who are serving in our volunteer program. But this might be helpful to kind of look at the specific requirements, the petitioning process and those kinds of things. It does generate a certificate at the end. You don't have to send it to me, but if you send it to me, it helps me keep track of how many people have completed it. And like, if you send me your thoughts, that's also appreciated. So that's another resource. And then the next few slides are just more resources that I think it would be helpful for you all to have. The first is the Legal Services of Northern Virginia. So this is the largest legal aid legal aid organization in Virginia. They're serving our low-income populations. They provide services in a variety of categories. So you've got your consumer law. Mostly for us, we're looking at elder law, family law. They have staff that provides legal advice, brief services, representation in court hearings. So that's a great resource to call if you have any questions. And then I also have listed, these are some of the elder law attorneys. I know we say elder, and most of your children are not elder, but they do a lot of the guardianship, conservatorship work. So these are the ones that I see frequently that get a lot of petitions just through the county. I've spoke with many of them, and they're all very friendly, super easy to get in contact with. So this is just a good resource to have on hand, I think. And then more resources, because I am a proponent of never having too many resources. So the first one is me. You can email me anytime if you have any like specific questions, really individualized questions. I know sometimes things come up. And then there's also anything from the VA courts website are documents created by the Working Interdisciplinary Network of Guardianship Stakeholders. So those all have been vetted at a state level and have a lot of good information about guardianship, conservatorship. The third one is where a lot of the information about least restrictive means comes in. And then I also linked the Virginia Legal Aid, Moms in Motion. Special needs planning is where I saw a lot about designating guardians in your own future planning. And then the supported decision-making agreements, the Virginia Department of Behavioral Health and Developmental Services has a plethora of resources. I frequent those myself, so those are just a few. And then I'm sure there are questions, so open the floor. After I figure out how to stop sharing. Where are we at? There we are.
Thank you, Denise. One question I have at the beginning of this whole presentation, you said 136 people with developmental disabilities have guardianships in Arlington. Were you able to get the ages of the people with developmental disabilities or the ages of the guardians?
So that's one, it's not very easy to pull. That's, I could pull it. It would take me a little bit of time to get the ages of the clients. Can I share? Yes. But as far as the
ages of the guardians, one of the reasons that Maimoon and I discussed you coming was to give us a snapshot of who out there with developmental disabilities is entering that age where their parents really do have to start planning for what's happening after they leave, or the parents may be becoming more weak and firm and unable to lift or otherwise care for their loved ones. So if we don't have a good idea, I mean, those folks that are not currently living in group homes, for instance, or may not be connected with the day programs, or may be working and may want to go to a day program or elderly program. So we want to know from a planning perspective, not just who's graduating from high school, but also who is likely to need, especially the group home services in the future, or need to hurry up and start. I know, Donna, you've told me about some aging 50-year-olds with 80-year-old parents who are moving on their own for the first time and stomping ground properties. So
Sherry, if I can also respond to that question, if you don't mind, Denise. So one of the things for individuals receiving active support coordination, specifically when they have their annual planning meeting, it is a required question to explore if the person needs a substitute decision maker, such as a guardian or power of attorney. So it's something that we are regularly and routinely asking annually and assessing for, quarterly as well. We also assess for every person when they're turning 18 for guardianship. And then we also do what's called an initial capacity screening that support coordinators do for individuals open to their caseload as well. And so it's asking, questions. It's actually a CSV form that is used in our electronic health record. That is followed by an A2 capacity evaluation if a guardianship is indicated based on that assessment. So, and we do that regardless of the age of the individual. So whether someone is turning 18, we do it automatically when someone is turning 18. But then I think we do it every 4 years for individuals that are over the age of 40, because we know somebody at a younger age, might not necessarily need a guardian, say with continue, but things change. Yeah. And so the older they get as the individual, they may later need a guardian. So there are a layer of different processes in our system to assess for someone needing a legal guardian. I can run a report. I can't, but Heidi can. So someone in our bureau can run a report that does show every person that has a legal guardian that is supported by DDS, and that can capture the age of those individuals as well. But that's for people already with the guardian. We don't collect the ages of parents and caregivers, so we wouldn't have that information to provide. But we do, and I think our support coordinators do a pretty good job of collecting that information. It is also something, one of those areas that is tracked by our CRT, our compliance team as well, in terms of just assessing our compliance for looking at that particular area specifically.
I wonder though, to build off what I think Sherry was saying, though, is when does one start planning, especially if individuals, I know with myself, for instance, as an individual with disability, I have older parents, who are, my mother, for instance, back to her 80s, and then my dad is, so. What?
Your mom looks really good.
Yeah.
I digress.
Yeah, but
fair.
Yeah, but I don't know how she feels that I just said that out loud. But the point is, so for people who may not have those resources now with planning, when do you start really planning? So that's kind of my question. Also, is kind of building off of that. Is at what point with people in odd situations with that?
And we start planning before they turn 18. So we have a team of support coordinators that are specifically designated to working with youth. We have 3 of them, and it's a question that we start asking before turning 18. So like Denise said, you can start the process as early as 17 years and 6 months. Right. And so the support coordinators usually know who those individuals are.
They identify
that. Right, but it's a conversation that we're having with parents in general at that time.
And we're looking at guardianship, people, aging people with developmental disabilities. And Joe, I don't consider you to be an aging person with a developmental disability, but the aging guardian, ages of the guardians, so that we're
power of attorney,
or well, people that we can count. So I don't know if you have power of attorney in your database, but we're concerned with the numbers of folks that are out there that are likely to need supported living.
Right.
Who have aging parents who, we may not be eligible, for instance, for the Medicaid waiver because they may not be ready to, they may be taking, going to their grave and then hoping something's going to happen for their person with a disability. But we'd like to see some planning put in place so that we know who we're likely to need to help for planning purposes.
Right, and I guess what I'm thinking, because I think the planning is there, so I don't want to create a problem that doesn't exist or suggest a problem that doesn't exist, because I think that our support coordinators are effectively having those conversations and planning, but we do not capture the ages of parents and guardians, so we would not have any way in our electronic health record to provide data to say who that is. But we have various layers to ensure that those conversations are happening.
Right.
So
that's one-on-one, but that doesn't help for planning purposes unless there's some way of understanding the aggregate information.
I'm not sure I follow.
For planning, we're talking about for planning purposes. The service coordinator may be having individual conversations with the guardians or parents of everyone who they're serving. But in an aggregate, what does the picture of aging parents and aging people with developmental disabilities in Arlington look like? Are they being cared for? Because they're not all in group homes. They're not living independently in their apartments. So who are they and what do they need for service planning, not for individual planning purposes, but for planning for the future purposes in terms of needing someplace to go during the day if the sister is now in charge. Who out there also has siblings who are now in charge? I know we had one person that came to one of our meetings who's in charge of a sibling and is doing the best they can, but they're not able to really do a great job. So for planning purposes, for groups, for Arlington County planning purposes, not for individual planning purposes, what does this picture look like? And how can we be assured that they're not going to end up like one of my friends in a emergency housing for 9 months after his father died?
And I wonder, well, I was trying to connect with my thing was like, I considered myself in the same spot, was just saying like, just where I was just saying, just that there was just with the aging part of my parents, but I was just thinking that, I wonder if like, what is it called, where you have like the individualized plans,
Mm-hmm.
if you have something, I don't know if there's something similar with that, where you have almost a step-by-step, almost much broader thing where.
Yeah, I think that's what.
It's more spread out.
Yeah.
It's more, so you don't have where you have a backup where if this person can.
It's sort of projecting what the person may need.
Yeah.
Yes.
Yeah.
Instead of letting the situation fall apart.
I can.
It's not just the plan, but it's
like
just
3 or 4 friends who have
supports.
who have aging parents who have been in the hospital, and you know them too because you've had to take care of these situations. Parents have to go to the hospital, and they're the only parent that's left, and that parent is nowhere near necessarily saying, okay, well, I'm too incapacitated to continue to care for my person.
But the other factor though with that, Sherry, is too, it's still also choice, because there are individuals that we support, and again, this is not, and I say this with confidence, this has not been an area where it's been a problem in terms of individuals getting legal guardians that need legal guardians across the board. It has not been an area of unmet need that we have identified in developmental services. Are there outliers? Absolutely. And those are often driven by choice. And so we have individuals, in fact, I had a parent literally just last week who we know, needs a legal guardian for their aging adult child. And the parent refuses, even with our offer of support, to become the legal guardian for reasons I don't fully understand. And we're in that situation, we're working with a sister and trying to become the legal guardian for that individual. But it's still a choice. We can't force someone to become the legal guardian for someone. We recognize the need for that. And so on a case-by-case basis, we look for other people, typically, usually for us, starting with relatives, that can step in to be someone's legal guardian. But those outliers does not represent even the majority of people that are supported by developmental services needing a guardian.
Okay, and we're trying to approach the aging parent, aging person with a disability issue by looking at the only place that I think Maimuna thought we might have data, which is the guardianship program. So I'm not as concerned about people not having guardians as I am about understanding the aging disability. Once the Medicaid waivers took the age of parents off consideration for priority placement, parents no longer had that time on the waiting list to look forward to. It's now either Arlington finds a placement outside the Medicaid waiver.
No, not for residential services, we do not.
Okay, so then let's, what's that pent up demand so that we don't end up with people that are in emergency services because a parent has become disabled or passed away.
And that would be if the person qualifies for a waiver, that is one of the criteria by which we can request an emergency waiver slot from the state, if that were to happen. There is a mechanism in the state for requesting an emergency slot.
But are we planning for people?
I believe that we are. I do believe that we are, yes.
And how do we know what the demand is then? Because we on the committee don't know, but you know. So how do you know what the demand is?
Can there be I wonder, because you say we don't, take information about the parents and the guardians.
We don't take information about their ages.
Their ages, excuse me, yeah. Is there a way to do a voluntary type of,
I wouldn't know.
A type of study or some type of thing to do a report or anything like that?
Yeah, is there any way of finding out the ages of the DD population in Arlington so that you can sort of see who's...
Right, and I had mentioned that. I mean, we can provide, we know the ages of everyone that we support, so in terms of getting reports that show the ages.
It would be interesting to see what the spectrum is.
And by who has the waivers, who's being monitored, because I assume that there are people out there that are not receiving services who are being monitored and who are getting up there in age, right?
But that then becomes an area of need for even somebody that's monitored. And also the majority of individuals that are in what's called the monitored subunit for Arlington County are children. And young people, they're not older people. The majority of older people that we support have services, have waivers. Because the older you get and your needs are increasing, your priority level is changing. So the majority of people have a waiver that are the older individuals.
And so it would be good to see a picture of that. Are there any other questions about guardianships for Denise?
I have a question. So if you have a co-guardianship, two parents, in this instance. In the past, this is just our story. I hate to do this in a meeting, but I might as well get my answer. I've done the report. The last time they said we both needed to file a report, so can we just Xerox the same report? It's the same report, we do everything together. But we actually need to have two separate, we're gonna say the same thing. Or can he just sign on my report? Can we have two signatures on one report?
So, I'm going to tell you how I accept them. I don't know if all of the jurisdictions do this, but I think it's silly for you to Xerox the exact same report and send it to me. So if you both sign it, that's typically how myself and the clerk are accepting them.
Okay, that's perfect. That's what we'll do. Thank you.
Because I've had people that the first time they're appointed, it's the mom, the dad, they both live together with the kid, and it's the exact same report in different handwriting. And I call them and go, you don't have to do that. That's a lot of work. You don't have to do that.
Well, we've always just done one, and then they asked us to, where's my husband's report? I was like, okay, got it. But now, I think they just wanted him to sign somewhere. Well, Arlington asked us, but that's all right, and it's due, so I was trying to do it right, and here you are to give me the right answer. So we'll both sign the same report. If they don't like it, he has to write it in his own name.
I mean, I will like it, so it's fine.
It's going to come to you. So
yes, so it's fine with me.
Okay, perfect.
And then you did offer supportive decision making as one of the resources, and I wanted to add that the ARC of Northern Virginia has training and very good information on supportive decision making. So for those of you who have guardianship, as Denise shared, you don't have to have guardianship for the rest of your life. You can look at other options. And so that's an opportunity to consider something different. Okay, one of the things I wanted to hear from are some of the aging parents, and I asked folks to speak up, come and speak up, and we can hear from them. So does anyone want to share?
Wait, can I ask one more question, Denise? Sure. I wanted to have your email. It looked like it's A. McDonald. Is that correct?
Can you put it in the chat? Oh,
yes,
no.
I'll put it in the chat.
Okay, thank you. Sorry.
Oh, and then I can make a PDF of the slides and I'll send them to The Voice.
Yeah, to The Voice.
Yeah.
Yeah.
Okay.
That's good.
Okay.
Thank you.
Thank you.
I did have one very quick. I'm just curious, like with the whole chain of the process with the circuit court and that, how long does that take usually? For the guardianship and conservatorship, how long does that usually take, the chain with guardian, the evidence, the hearing, initial site, and then the court order and that? How long does that usually take for guardianship and then the process for the conservatorship?
That's a great question. I'm not really sure exactly how long. I think you're looking at maybe like a month or two. It really just depends on how fast things get going. I know for our cases that we petition, they don't really take more than maybe like 6 weeks or so. But I don't know if that's because we're petitioning and that's how it works. The guardianship and conservatorship, you can do them both at the same time.
Thank you so much.
It's usually about 4 to 6 weeks. The court, I know for Fairfax County and Arlington as well, require a minimum of 2 weeks between the time that you are submitting your petition, your request, and the time before the hearing can be scheduled. It's not likely to be scheduled in 2 weeks, but you need to have that time buffer as well. So you can't file 1 week and expect a hearing the next week. Right. So even when our county attorney is filing on our behalf, we have to require a minimum of 2 weeks, but it's usually the process about 4 to 6 weeks. And then you have whatever time before then that you are allowing for getting the documentation that you need to submit with your petition, such as a capacity evaluation.
And is it possible to get a copy? I don't know if this was asked about the PowerPoint.
Yeah, you'll get the PowerPoint from LaVoy's.
I didn't know if someone asked that.
Through the BD list. Anybody want to share a little bit about concerns of parents or concerns of people who are receiving services who have aging parents? this meeting. When Maimoon and I were discussing the agenda for this meeting, we conversed about how with all the listen and learns, it's like, okay, everybody, we're getting a lot of information here, but no one's really providing input the same way they were before we joined this. And so I think it's important to listen to folks who have been committee members or who have concerns. And so anyone have anything they want to share?
I have a concern, not as a parent, but as someone who's in an organization that's encouraging families to do more inclusive, affordable options. Maybe a little more allowing the adult to be a little more self-directed, which is all exciting. But so we just see a lot of people, and I agree with the voice that I think it's not so much, it's the people that just aren't going to prepare or are just going to wait, or they're so overwhelmed that they're not picking. We see a lot of families that come really close and they're ruled and they just kind of pull up the drawbridge and they're just going to let it happen. So I don't know what anyone can do about that. We can still just try to educate families. I will say that the ARC in Northern Virginia had offered a tour of one of our properties and just a little talk about, how can you make community, how can you find your people, how can you consider housing? And we're never going to be the answer for housing for everybody. There's just no way. I mean, our 3 Arlington properties, we'll probably have 2 more. They're all full, no one's moving out. But we are trying to help people make community. But I will say, typically when either Jeannie Cummings offers something like that or the ARC offers something, 10 people show up. Last 2 weeks ago, we had 104 people RSVP.
Oh, no.
So a lot of older parents who just kind of said, no way, you do see that something is happening. And I think that's great. But now it's like, oh my gosh, that is a lot of people. So that is overwhelming. But the other thing we're seeing is that we are hearing people say, well, I think we're just going to leave our adult child here and we're moving. And we've seen families already do this. And I'll be honest, that is, I want everyone to do the best thing for themselves. And there's nothing I can do about that personally. But I am starting to almost feel like that's a trend. And that is alarming to me. And so these are people that you're not, they're just sharing with us. And I think everyone should do what they think. But I don't know what those outcomes are going to be. I mean, we already have someone in crisis now because.
And we have that experience, and parents, you can move away. We will support the individual because we're not, we are supporting the family in a sense as well. And so we have a number of guardians that live in other states, and that's not a problem for us. It becomes a problem when that parent moves away and they have the expectation that the county, in a sense, is becoming the parent and the guardian. And we can provide support coordination, but we are not legal guardians. And so when that parent, is physically moving away and they're just stepping away from their role and responsibilities, and then it becomes more difficult, that's when it becomes problematic. That's not the norm, but I would agree with you. We are seeing that trending up more than I would like to see that.
No, and you don't need and I would just say for this, new nonprofit, you don't need very many of these, and I'm sure it's true in your organization. You don't need very many of them to kind of hamstring everyone because it's something that no one can walk away from.
Right.
So it even before it's a crisis, it is really worrisome. But so that's all I'm saying is it seems to be a trend. It's expensive to live here. The parents kind of feel like, we've got it set up and now we're leaving. And I totally respect that someone wants to leave.
Is there a way, I'm wondering, you mentioned, the expenses, that's one of the things, but is there also, could there be other, and I know Lucy mentioned that there's, kind of caring for the caretaker thing going on. I'm wondering if there's also just, some other stuff going on with parent guardians and that. Is there, any, stressors of being a guardion, those type of things.
None of those.
But I wonder if there's elements there.
I'm sure.
I wonder what I have no idea. what ways could we, or what could look into trying to make sure that, as you say, parents can move, people move, but to keep them involved and keep them, here. Is there any way to I don't know, kind of make people aware of the commitment, that comes with that, because I don't know.
No, you do know, so thank you.
Well, I think just as much as the DD population itself becomes isolated, I think the parents do too. And I think that that's unfortunate, but you really struggle to not let that happen, but it does. So,
and I think there's, people, particularly, I might be biased, but here in Arlington County, I think because our support coordinators do a phenomenal job supporting the individuals, that I can appreciate that a parent, whether that parent chooses to move away, that parent is aging themselves, having the confidence that your son or daughter is going to be just fine in Arlington County, when you are no longer here. And I personally want to give every parent the assurance of that, whether you choose to live in California, in Minnesota, that we are going to take good care of your son or daughter. We want, when you're the guardian, for you to still stay involved and be involved, so you're not isolating that person. But the way that we certainly support individuals, we're not going to have someone in our county that is lacking of something, that's going to be out on the street or homeless, being a person with developmental disability. And so whatever the resources ultimately it takes, but that should not be your plan.
right.
That's the difference. That shouldn't be your plan. There is a responsibility in planning for your son and daughter, and the county may, in many instances, be a safety net, but that safety net should not be the primary plan.
Well, didn't they sign, there's a thing you have to sign, that was mentioned, no, right, or something?
When you become the guardian,
Yeah.
but for individuals that you are not designating, whether there is no guardian, and even
Oh, no, but I was
people
talking
that
about the
sign,
guardian.
right, but even for people that sign the oath, that doesn't mean that, everybody that's a guardian is doing what they should be doing according to that oath.
So there's nothing that you can do, so if someone's not doing their job as a guardian, is there any, what action?
Well, 3 visits a year.
And one of the things I'm just gonna pause the questions for a second.
Sorry.
People can ask questions, and I'm writing the questions down. But I do want to hear from folks who have been sitting quietly. So Lynn, you shared about some of the isolation, and I think Moira is the next person.
I know we became guardians when we created a will. Actually, it was the trust. So we were goaded into becoming guardians for our kid who really needs guardianship. And that's when we did it. So, I can imagine if you're putting off doing your will, your trust, you're probably also going to be putting off guardianship. And I just want to encourage people, it's not a good idea to put it off. Do it. You can always change it, right? But just do it. Thanks.
Thank you.
Yeah, I would say from personal experience that we avoided making plans because it's hard to do, and I can understand that the support coordinators running, and I'm a planner, so I know that I have a natural propensity to do that, and there was a lot of backing away from it, so I really do understand.
And I would also add, in part because this is being recorded, and so if this is helpful for somebody that may not be watching this in real time, is that if finances are a reason that is a barrier in terms of applying for guardianship, there are some instances where we can offer assistance in filing the petition under the department So the department would be the one filing the petition on behalf of the individual. There are income requirements, so, for that, so we can't do that for anyone, just, needing a guardian, but certain people or individuals that meet income requirements. We do ask that you first explore in those instances free legal aid services or legal aid services here in Arlington County. And if that doesn't work for you, then you can reach out to the support coordinator in the event that the finances is a barrier for applying to become someone's legal guardian. That is something, an area where we might be able to assist.
Thank you. Lucia?
Just a couple of things for us to consider, if Sherry, because if you're looking at numbers of people, over the last 5 or so years, there have been so many more FIS waivers given and very few CL waivers. And I think we need to consider for all the people either who don't have waivers or the people who have FIS waivers and don't therefore qualify for group homes or sponsored residential, where they need to have more help, whether they're in an apartment or in their own home or sharing a house with other people. When aging parents die, will the aging parents be able to continue to juggle all of this when the aging parent goes to the hospital, like you mentioned, Sherry, or dies or whatever? How to be sure that those numbers of how to plan for those numbers of people that might be on an FIS waiver, and it will take a while for them to not only qualify for a CL waiver, but I heard Denise or Lavoie say it takes 4 to 6 weeks, to do the court appointments. So I think that might be a question also, not only age of individuals with DD waivers, but also the kind of waiver that they have, because if they don't have a group home and they're not already placed in something that's got some wraparound services that can be managed when their guardian dies and the replacement guardian comes in, that would be another question of who will be the backup, and the support coordinator can process the paperwork, but they're not going to be the actual on-hand backup. And then I had a question for Denise, which was the new thing this year that guardians must visit the individual 3 times per year. So what happens then if individual they have a guardian, and maybe they're living in a place like our stomping grounds, one of those more integrated housing situations, the parent moves away. And this question may not be for Denise, but just a question for us to consider about what happens when those guardians move away. And then what if they don't visit 3 times a year? What happens then? There's not an answer for this really right now, but I just wanted to consider that question too, because parents may have other responsibilities to other children, or they're an aging relative or a sick somebody.
Or they're in an assisted living themselves, right?
Right, and they're unable.
Or they're incapacitated, or they have dementia, and maybe they didn't change the guardianship before their dementia got so bad. So there's these things to consider. I just think especially with this push to integrate people into more or less restrictive situations, the more people we have living in apartments or their own homes, when there's not the parent and it falls to the sibling, or there's no sibling, right? And then where does the backup come when the 80-year-old mom dies? So those ages would be really great to know about the parents of people with DD that the CSB is assisting, but obviously that's something we can't know. But at least if we know the age of the individuals, that would be really helpful. And what kind of waiver.
So I can say in terms of, I'm sorry, my cat has decided that she wants to join our meeting. Train of thought. There it is. Okay. In terms of like 4 to 6 week period, it tends to be quicker to do a substitution because in a lot of cases, the court sees that person's already been deemed incapacitated. We just have to go to the hearing to do the switch. So sometimes that's just the waiting period to get on the docket. So that one tends to not be quite as long unless somebody's contesting it. And then for that 3 times a year visitation requirement, There's a lot of room for extenuating circumstances. As it's written, one of the visits has to be by the guardian in person. One can be virtual by the guardian, and then, or in person by the guardian, or someone authorized by the guardian, another family member, someone that you hire, a case manager, something like that, that files a report with the guardian. Or it can be virtual, and then the third can also be virtual. But then the code is written as such that there can be made allowances for certain situations, and it's very individualized. And there's also, we've gotten no guidance on what exactly happens if those requirements aren't being met, other than when we see it on the report form to flag it for the court and go from there. As something else that's new, that wasn't in my slides because I didn't think about it, but something else that's new in the code are periodic reviews of guardianships. So the court can pull, I think it's only new ones, but they can pull any for review when they feel it's necessary. But new guardianship cases are subject for a review within a year of being appointed. So that would also be an opportunity where if those reports are being filed and the requirements aren't being met, to kind of address it there.
Joy?
Hi, I'm Joy Haley with Arlington Public Schools. I wanted to go back to, I think, LaVoice, what you said a few minutes ago, just to get some clarification. So we start talking with our families and, as early as possible about, guardianship process. We, have some really wonderful presentations that were given by the ARC that talks about informed decision making. And of course, we promote all of that, like the Lunch and Learns and all of the events that they have where families can learn more. But I still find that we end up with a lot of families where, they might be 20, 21 years old, or maybe even getting ready to exit, and they still really haven't started the process. Sometimes it is has to do with financial. So LaVoice, I wanted to go back to what you said, that we refer families to legal aid sometimes, but you said that sometimes they could maybe get assistance through their support coordinator. Do they need to go through legal aid first and be told that they don't qualify to then come to DD, or how does that work?
They need to first go to legal aid and be told for not qualified, because if they qualify for services or assistance through legal aid, then that's a resource. So our county attorney's office should be a last resort for individuals that need financial assistance in applying for guardianship. It's not a first response. So they need to rule that out. And okay. You probably have given us a number of referrals yourself. I know we get usually at the beginning of the school year, we get a list, from individuals, and so we are asking and requiring that be ruled out first.
Okay, thank you. And then I just have another question. So each year when we do our transition fair for Arlington, we generally do it November, December. We usually try to invite a couple of local attorneys that can talk with families about the guardianship process. Each year that we've done this, we have had people come, except this last year. None of the attorneys that we had reached out to were able to come. Do you have a recommended list or a list that you give your families that maybe we could send out to our families at APS?
Oh, is that well, Denise gave us a list in the PowerPoint, so you'll get the PowerPoint afterwards, and she had, it looked like about a dozen attorneys that she's worked with who were
Thank you. But is that something, will I be able to access that and send that to the parents? Is that okay? Like the whole presentation, or?
Yeah, everything is public information. Everything is public information.
Okay.
I have that chart separately. If you would just put your email in the chat, I can just send you the chart.
Thank you so much. Yes, I was just thinking, I've had the list, it might be easier than, because, we send out lots of presentations, and I think sometimes parents, it might be, they might have a hard time going through finding the specific information that they're looking for. All right, I'm going to put my email in the chat. Thank you.
Okay, perfect. Yes, of
And
course.
I would also remind you that this is being recorded, and so there will be a YouTube link of this that you are welcome to share with families as well.
Thank you.
So we have time for one more comment, and then we're going to go to the Voices update. Anybody else? Is there someone with their hand up?
Carol.
No, I see number 8.
No,
Oh,
that's
18.
18.
Who's?
But you have to click on it to see who it is.
Oh, it's Carol. Okay. Thank you, Carol.
I just am trying to get a better sense of what the county's role is in pursuing or supporting or trying to find guardians for clients who are on our caseload who are clearly incapacitated and need one, and don't have one or don't have an authorized representative maybe for services. I guess I've always been worried about people who end up sort of being orphaned in the system, kind of like, you know, an aging parent dies and the person's already living in a group home, but there's really no obvious persons to step forward, or no one's been designated to replace the guardian, or the parents, you know, somehow somebody moves away. I mean, all of those situations. How proactive is the county in trying to ensure that people in those situations have guardians, and what actions could or do you take, I guess is my question.
So I can answer and tell you what Developmental Services does for individuals with disabilities, and this is not speaking on where in terms of our county attorney's office, because it's neither their role nor responsibility in that respect. But again, to the point that I made earlier, our support coordinators are routinely assessing for individuals needing guardians, and that's whether they are receiving, you know, for those that are known to us, active support coordination, and those that are receiving monitored support coordination as well. And then if assistance is needed, that's something that we also explore as well. It doesn't, you know, I've been in my role, Carol, for 8 years, and I can probably think of one instance where, you know, a parent passed away, and then in that situation where the individual didn't have a guardian, and we were able to identify, I think, some distant cousin that lived somewhere in Florida, but we supported that individual, that relative, in terms of seeking guardianship for that particular person. But in that case, that person was already in a group home. So in terms of where the person was living or needing to make changes or something like that. And then that was a situation where the guardian actually had passed away, not someone that didn't have a guardian.
So everyone in group homes have guardian?
No, that's not, not every person in a group home has a legal guardian.
Or someone who's looking after their care?
They have authorized reps, because that is something that that meets, you know, our needs, you know, as well. We certainly recommend people having a guardian, but they can also have an authorized rep. I would say the majority of people do have a legal guardian that are in group homes, but there are a handful that, very small handful that do not. But they would have an authorized rep. They could have a power of attorney. They could have a substitute decision maker, because a legal guardian is not the only recourse in terms of having a decision maker supporting that particular individual.
I can also speak a little bit on that. So when the situation arises that, say, the guardian is passed away, no longer able to serve, the support coordinators can reach out to me. We have our volunteer program, which is made up, it's got practicing attorneys. We also have community members. And we work to kind of match the client with somebody who meets their needs. They think that, like, you know, they would just mesh with personality wise, or finding an attorney if that's what's required. But we also recommend depending on wait list, going ahead and getting that person on the wait list for public guardianship, just so all of the bases are covered. And then whichever one comes up first, great, we've got it taken care of. But I can think of an instance where that has been the case, and the coordinator worked with me, and we were able to identify a guardian and get them substituted.
And I would really just put a plea out there, because I think that is one of the most important things that you can do for your son or daughter with a developmental disability, is to assess whether or not they need a legal guardian. And if so, and you are not able to, for whatever reason, to identify that, because that's not something that you want to leave to the county to have to do, to make such an important decision for your son or daughter. I say that as, as in my role here, but also as a parent of a son with a developmental disability as well. That's just not a responsibility that you want to put elsewhere, nor a burden that you want to put elsewhere as well, because that's a huge responsibility for us of having, if that happens and someone passes away suddenly, to have to be the ones to make those decisions for someone's life. So I think it is one of the most important things that you can do as a parent of a son or daughter with a developmental disability, is to explore guardianship if that's needed. Not everyone needs it, because you don't want to go to court and remove someone's legal rights if that's not indicated. So I'm not saying that every person with a developmental disability needs one, but some people, it's quite obvious and apparent that this person needs a guardian. And we're not saying that you have to be that guardian, but at least exploring and having those conversations with your support coordinators, because that's an area that we absolutely want to assist with in ensuring that people have legal guardians if it's needed.
Okay, thank you, and thank you, Denise. Don't worry, we won't end on time, because the voice only has her updates, and we have some updates from the providers. And I only have one of those.
So my updates, the obvious ones, Irving Street and our employment readiness program to start. But I think since we last met, and I was hoping she could come tonight, but I'll see if she's available next week. So we have filled our employment habilitation transportation contracts manager. Many of you may recall that Elizabeth Cannon, who was previously in that role, resigned that position in October of last year. And so we have filled that with the new person. Her name is Melissa Jesserum. She comes with a great deal of contracts experience working for the city of New York, and has been on board getting acclimated for about a month. She made 1 month yesterday.
And she's still here.
Okay. Yeah, she's doing great. I know. And we're also grateful, because we're working in the process of bringing Elizabeth back for until the end of August to do some assistance and training and onboarding her as well for limited hours each week. So that is also in the process. Thank you, Maimuna, gracefully, for supporting that and agreeing to that. We also are close to getting the COO, the Certificate of Occupancy, for the new employment readiness. We were supposed to have a temporary Certificate of Occupancy last Friday, and so that may have happened. I have to double check on that, but we're pretty close to getting that finalized. The space, for the most part, is done. There's some, few wiring of things for computers and things like that, and phone lines that we're still working on doing, but otherwise the space is pretty much ready and close to completion. We are nearing the end of the process, hopefully, for selecting a provider. We're still in negotiations there, so that's still in process. So no decision has been made on a provider, but hoping that'll be in the next 3 to 4 weeks, having that finalized. Irving Street is pretty much close to completion as well. I did a final walkthrough last Friday of the punch list and some last minute items. So just some minor things that the builder is working on finishing up. And we're nearing the end process, likewise with the RFP process and selecting a provider for operating that particular home. What other updates am I missing, Maimuna, just in terms of staffing? Those are the major things. Question.
Do you have a provider for the group home?
That's the one, so Urban Street. We don't have a provider yet for that group home, but we are in process of selecting a provider as well. We are planning an open house, sort of a two-tiered open house, because it'll be the same day, but given the number of people that are interested and that we want to have at the grand opening, we'll have sort of celebrations later, I think late in September. We're looking at that, so we'll send out information about that, and then there'll be opportunity to do tours of the home before residents move in. Once people move in, it's their home, so we're not gonna, have any tours or anything, but there will be an opportunity for that beforehand. It's an amazing, beautiful home. So.
Yeah, a quick question. I don't know if this was covered, I may have missed it, but was there ever, because I know there was a whole thing with the nurse on staff, nurse with Irving Street, or was that ever figured out?
We do have, that was a requirement in the RFP.
They were able to figure out with getting a 24-hour. Was it 24 hours? Was it someone?
No, it was not. It was 40 hours a week.
40 hours. Okay, that's what I was trying to figure.
And that was a requirement in the agreement.
Okay.
So I can't speak to anything about the RFP yet because it hasn't closed yet.
No, I understand.
Yeah, it was a requirement.
I just remember that was on the proposal.
Yep.
Sorry.
And just as a reminder, because the majority, you were on that committee,
yes,
the vast majority of those recommendations from that work group, I think all but maybe two, we were able to incorporate into the scope of work.
Yeah, it's an important thing. Anything else?
Nope. Unless Maimuna has something else.
No. LaVoice, I think you covered everything. I did have to step away and then I came back. I wanted to make sure that there was mention of Melissa.
I did. I mentioned her at the top.
Great. Well, that was the point that I missed.
We do have a program manager vacancy. So David, I think since we last had the CSB business meeting, so we have a program manager vacancy that we are actively working to fill. So we've done, our interviews are finished for that, so we're in process of filling that position, that vacancy.
But they're all the service coordinators are.
We are fully staffed for support coordination.
And I have mine are very quick also. We are not meeting next month, August. And I did send out an update and said that our next meeting is Labor Day, but it's not. It's on, thank you, Moira. It's on Tuesday, September 5th from 4 to 6. It will be a hybrid meeting. And I guess Bertra, LaVoice, Maimuna, and I will discuss the agenda for that. If you have any suggestions, let us know. As a follow-up to Carol Skelly's public comment last month, LaVoice, Carol asked some questions about the CIP input process. Can you answer?
Is Jim on the call? I don't know that I'm best with the CIP. I don't have those questions in front of me. So Carol, if you have the questions, I can try to answer them. But if it's about the CIP process specifically, I'm not an answer here. Maimuna might do better answering CIP questions.
I think Carol was asking about, we can pull it up because it was sent to all of us.
Yeah, I don't.
I have it in front of me. So. And in the meantime, while LaVoice has a chance to take a look at the questions, are there any updates from our provider community? Any provider updates?
For CRI, no update from CRI.
Anything from Service Source?
Yeah, I can just let you know that Arlington Weaves will be at the Arlington County Fair. So please stop by our booth and check us out.
Thank you. Melwood?
Really no updates, just trying to get everybody back into day programming, getting our numbers up. That's it.
So you have current vacancies for the upcoming fall?
Yes, ma'am.
Great. Is there any of the day program providers who do not have vacancies right now?
Arlington Weaves is full. And I believe that Woodmont CIC has one vacancy.
But we are in process of referring, someone is being referred for that. So there are 0 vacancies.
0 vacancies.
The one that is there is in the process of being filled.
Okay. Are there any other providers who are here that would like to give us an update?
How is their hiring situation? Are they able to hire? That's what the providers.
So did you hear that Lynn has a question of the providers of whether or not you're able to, whether you're continuing to have staffing issues that limit your ability to serve clients?
As far as Melwood is concerned, really no staffing issues. I had someone resign probably about 3 months ago, but I am in the process of filling that position. The person has to come out and do the written piece for the interview, and we will be back up to having 6 specialists. So that when we do get our numbers back up, we will have staff available.
Thank you.
So no issues with staff.
Thank you. LaVoice, were you able to read the, okay.
So the first question I have, will the new facility provide only day rehabilitation programs, or will it support a hybrid of day and employment options as recommended by the public consulting group consultant? I'm assuming by new facility, Carol, you're referring to the employment readiness program?
Yes.
LaVoice, no, these questions are about the permanent capacity that's being planned and is supposed to be on track to be proposed in the CIP next year in May. I mean, presumably that planning process is going on now, but very little information has been shared with the committee. And it's a, it's a big deal. It's one of the most, I think, important things that will be coming along, now that Irving Street is opening and the other programs are being in place. This really is the piece that was supposed to support growth in day programs over a 5-year horizon. So the questions all really relate to that.
Okay, so some of these questions I can answer, and a couple of them, or at least one of them, I cannot. Yeah, I think in general, we are looking to have more program flexibility in terms of people being able to attend kind of a hybrid approach, if you will, of day support and employment, of moving in that direction. That being said, it is ultimately the provider's determination in terms of their capacity of being able to do that. It is something, though, that what we're looking at as far as what we would be asking for is that flexibility, is having programs that are designed and structured to be able to support people if they so choose to do a combination of employment and hybrid. It is certainly a model that we would be requesting and pursuing in that respect. That being said, if that's not a model that a provider feels that they can support, that might be a reason that they don't respond to an RFP. So we can't force someone to do that just because that's the direction that we are looking to go in. And that also depends with more traditional day support. I don't perceive that as being a barrier there. What method is the county using to project a target capacity that will meet future needs? We have projections for our students that are aging out of services for the next 5 years, and can look beyond. But we're working on data, knowing what the number of individuals that are aging out over the next 5 years for services, and anticipating expansion of day support and employment services, because we know that we are seeing a higher trend, a larger trend of individuals that are also going into employment and not just day support. And then we are also looking at the capacity of people that are in programs outside of the county that are looking to return. Shortly before Elizabeth left, also we were doing some cold calling, reaching out to families that were had individuals supported in programs outside of the county to gauge interest in the event of developing more programs in the county. Would they be interested in coming back to a program? And so with Melissa being on board, we're hoping to resume being able to resume those calls of having the staffing to be able to reach out to families. So that is also a part of our projection for our targeted growth. And then we also will take into consideration those individuals that are currently attending day programs that are retiring from day programs and that are choosing to not do, to have different plans and activities for their meaningful day other than day program as well, are things that we are taking into consideration in terms of the capacity for future growth. And factors being considered in identifying a location for the new program. We are largely focused on looking at at this time, existing county space, as that is going to be the most cost efficient for doing that.
As opposed to building new place.
As opposed to looking at private retail space. A private, space. Maimuna, do you want to add anything in there?
No, we are looking forward to really building capacity, and LaVoice and her team has done an amazing job with looking at the 5-year plan, and we're excited about our employment readiness program, as she mentioned, that is coming online soon, as well as the Irvin Street. But we know that the trajectory will build capacity, but it's quite a process. And we recently met with our DHS director, who gave us guidance, Anita Friedman. So it's really a preliminary stage, but as LaVoice mentioned, on-site leasing space from Arlington County is going to be more feasible for us rather than having a build out. So we'll look forward to keeping you updated.
Could I just, do you have time for me to ask a follow-up question? I see that it's 6:05, or shall I just?
I think we have to end the meeting because it's beyond its registered time. But Carol, if you can send Bertra and I your questions, we will ask them of LaVoice and Maimuna at the next time that we do it. Just send it to both Bertra and I, and we will follow up. Thank you, everybody, for attending. Do I have a motion to adjourn?
So moved.
Yep.
Okay, we have a motion, a second, and if anyone wants to stick around afterwards, then you're going to be very lonely. Thank you so much, and have a nice month off. Take care.
Good night, everyone.
Bye.
Good night.
Thank you.
Good night.